Hello and welcome. In this lecture, we'll be delving into communication about legal services. The topics covered are advertising, solicitation, group legal services, referrals, and communications regarding fields of practice or specialization. Advertising, under Rules 7.1, no false or misleading communication is permitted by law. That means when advertising, lawyers need to be truthful of their services and areas of specialization. A lawyer must not make false or misleading statements about their legal services. Now, a statement is misleading if it contains a material misrepresentation of fact or law, or miss a fact necessary to make the communication not misleading. For example, if a lawyer states that they're the best lawyer in town, now that can be stated with provable, verifiable data. Misstatements such as, we can get you results. Now, if a lawyer states that they have won 200 cases, when in fact the verifiable data shows that they have won only two cases, for example, immigration law, that is a statement that is misleading. Now, puffery is usually okay if it is not misleading. Now, what is puffery? Puffery is a subjective opinion or boastful statement. Therefore, it is not a violation. A statement such as, we're the toughest lawyers in town, we don't back down. That is simply a statement that is subjective. It is more likely to cause an aggressive advocacy, which is really sometimes permitted in many jurisdictions, for as long as it's not deceptive. It's not illegal because it's not a promise for any specific outcome. It doesn't misrepresent credentials or results, and it's just an exaggerated language. When it comes to advertising, lawyers need to provide their name and contact information, or at least of their responsible lawyer contact and name information. Adverts may be about their fields of practice, their fees can be included, and they can make legitimate comparisons of their services, um, things they have achieved so far, and so forth. Now, lawyers cannot pay for a recommendation unless they're paying for ads or leads or they participate in a qualified legal service plan. Many companies do have a or a part of a legal service plan where payments are can be made by clients if they subscribe for legal services. So that is allowed. Solicitation is a communication initiated by or on behalf of a lawyer that is directed to a specific person, offers to provide legal services, is motivated by a pecuniary financial gain. Now, direct solicitation is prohibited by law. Lawyers may not solicit professional employment through live in-person contact, telephone calls, real-time electronic contacts. So those methods are not permitted by law. If it's going to be a direct contact with clients in order to solicit services. However, there are exceptions to the rules where solicitation may be permitted if a lawyer contacts another lawyer in order to advertise, talk about their services, or through family members or close friends, also in situations of former clients. Now, for written, recorded email solicitation, those are permitted. A lawyer may send targeted written, recorded, or electronic communication, uh, and that is permitted because now the format here is not uh, direct, but it's in a format that the law allows. And they have to be truthful and not misleading. However, they need to be labeled as advertising material, and they need to include the name and contact information of the lawyer. And the language should not be coercive or have any elements of duress or harassment. Lawyers, however, should not solicit anyone if the person has clearly stated that they do not want to be contacted or solicited, or if the solicitation involves coercion, duress, or harassment. Okay? Or even trying to take advantage of vulnerable people. For example, if they've been victims of accidents or trauma or anything like that, that type of solicitation is not permitted by law. Now, for the MPRE, remember cold calling accidents of victims is not permitted. Sending out emails to DUIE arrestees may be permitted if written solicitation with proper label. Live video message inviting strangers to call you is not permitted. Now, remember the equation for the MPRE is real-time communication plus stranger plus paid work is a violation. So that means any real-time form of communication to a stranger requiring it to make payments for legal services is a violation. What's allowed is written plus label plus truthful communication is allowed. Now, group legal services refer to a lawyer participating in a legal service plan that offer legal assistance to members of a group at a reduced cost, such as union members, employees of a company, members of an association or nonprofit run by a nonprofit legal aid organizations. Now, it is accepted or allowed if it is not owned by the lawyer. Okay, for group legal services to be permitted, they must not be owned by the lawyer himself. The plan does not improperly influence the lawyer's professional judgment, and the communication to members is not misleading or coercive. So those are the three requirements for group legal services under Rule 7.2b 2 to 3 to be effective. And this here is just the same exception rule that I've stated in the previous page. Now remember the mnemonic NICE plan. For group legal services to be effective, they cannot be lawyer owned. They must be independent judgment, preservation. Client choice must be respected. Ethical advertising. Okay, it must not be misleading. Referrals. Now, referrals under Rule 7.2b, paying for referral is not permitted by law. The general rule, 7.2b. Okay, paying for referral is not permitted by law. That means a lawyer must not give anything of value to a person or organization for recommending the lawyer's services. However, there are three exceptions, and they are one, advertising costs, paying for ads, leads, or directories. Okay. Two, legal service plans, non-profit referral services. Lawyers may pay to participate in a qualified legal service plan or nonprofit referral program if they're not owned by the lawyer, as was stated earlier. Now, the client has a choice. They are independent in what qualified legal service plan they choose. Okay, and there is reciprocal. Number three, reciprocal referral agreements. Lawyer may enter a non-exclusive client form reciprocal referral agreement with another lawyer or non-lawyer in this case if it is not indefinite or exclusive, the client is informed of the agreement and no payment is exchanged for the referral itself. Those are your three exceptions how the referral program should work. A situation when it is allowed. Fee splitting. Now, fee splitting between lawyers is permitted only if it is proportional to the services performed, the client gives informed consent in writing, and the total fee is reasonable. Now remember, fee splitting with non-lawyers is not permitted. Okay? It is permitted by lawyers, but not for non-lawyers. Now, for example, in the MPRE, paying a paralegal $500 for each client they refer is a violation because lawyer cannot pay for referrals. Joining a state bar referral program that charges a flat fee per case is not a violation. It's a qualified referral service. Referring clients to an insurance agent in exchange for their referrals is a violation. Can have exponential referral deals. Communication regarding fields of practice and specialization. Now, general rule, lawyers can state their practice areas. For example, they practice criminal law, they practice contract law, family law, if it is truthful and not misleading. For example, saying I focus on immigration law or I handle personal injury cases is allowed. Misleading specialization claims are prohibited. A lawyer must not imply or state they are certified in a certain area if they really are not. Okay? A lawyer is certified as a specialist by either a state approved authority or an ABA accredited organization. So that means that the name of the certified organization is clearly identified in the communication. Okay? If they say, I'm board certified family law specialist, it is okay if they can back it up with verifiable credentials. Specializations may not claim that they are, for example, expert in criminal law unless they actually can back it up by verifiable credentials. Okay, certified tax specialist, uh, they need to back it up too with verifiable credentials. Okay, lawyers may always say, my practice is limited to or concentrates in, handles mostly. These phrases are permitted as long as they are not misleading and accurate. Okay, my practice is limited to criminal law. It's limited to uh, family law. Concentrates in torts or contracts and so forth. Now, for an MPRE, remember, specializing in bankruptcy is ethical if it is not misleading. So if you're going to make that statement, remember, you can say it if it is exactly what you do. Okay, you're not misleading clients. When you actually practice another area and you know you don't do bankruptcy or you don't have any experience or credentials in bankruptcy, and then you stating that you specialize in that particular area. Certified criminal law expert, okay? And you need to have the verifiable uh, organization or accrediting agency that has provided you with that particular credential, okay? Now, expert at getting you off DUI charges is not ethical, okay? It may be misleading because it is guaranteeing a result. Okay, so that statement, you have to be careful there when you state it like that. All right, so we come to the end of this lecture, and I'll see you in our next one.